Dear colleagues, dear friends, first of all, big tribute to John and Melissa, as well as Noemi for bringing this great conference together. I think we heard really world-class presentations on the political developments with a particular angle of how they facilitate or do not facilitate political systemic reforms. And now we are entering the hardcore, in my view, most important systemic reform issues, that is to the question of implanting, or I don't know what word to use, the rule of law in these societies with traditions that are different from rule of law traditions. I'm very pleased that Vladimir Dobrovsky, in one of his first charts, explained the critical importance of rule of law issues, of transition from patronal politics, as Henry Hill called, towards a really reformed European type system. We are having another extraordinarily good panel, and I would like to follow the same order, if you allow me. So I would like to first of all call the panelists to the table, and I will ask Mihailo Zhernakov first to speak. Mihailo is embodiment of many things in Ukraine. First of all, by the way, he is himself a judge, so he knows, he was a judge, although he's very young, so but he was already a judge. And he knows the system inside out, so it's very helpful in designing reforms. In the wake of the 2013-14 Maidan events, a civil society was born or developed in Ukraine that is almost unparalleled. Also in its think tank and policy think tank branch. And really, there has been a tremendous human and intellectual capacity in this team, also uniting for quite a few years for reforms. And Mihailo is really the leader, and everybody would agree, of the rule of law segment of this community. So with that expectation, I'm asking Mihailo to explain how much chances we have to really turn the corner on these issues. You have 15 minutes. I will have to be very strict with time limits, unfortunately.
Thank you. Thank you very much, everybody. Thank you very much, Danube Institute, for inviting me here. Thank you, Kalman, for these kind words. I don't know, with these high expectations, how good my performance should be right now, but I'll try to manage. Well, I think it's fair to say that even though the previous panel wasn't about the rule of law per se, I think everybody who spoke mentioned courts or rule of law or something of this kind that underlies the importance of the rule of law in the democratic society. In Ukraine, unfortunately, the courts are very problematic. They are the least trusted public institution for many years right now. At about 14%, the level of trust of the people who trust fully or completely, or somewhat, with a huge mistrust. And there are reasons for that. One reason is that we unfortunately inherited the judicial system from the Soviet Union, and we never actually had any effective lustration or never built our national judicial system. And this is one of the reasons. The other reason is, and we inherited all these judges with their approaches, with the judicial system being the continuation of the system it was under the Soviet rule, when it was basically just in addition to the prosecutorial system that was never meant to protect human rights, that was never meant to issue the independent decisions. And so it remained in the independent Ukraine, and unfortunately, I also have to state the selection of judges to the system in independent Ukraine wasn't also good. It was in many ways negative selection. So we, instead of selecting good judges, we continued selecting somebody who would be dependent, who would be not working towards the protection of human rights. And if people, when asked what problems you see in Ukraine's judiciary, they often answer corruption, number one problem. Some 94% several years ago answered that this is the number one problem. Also dependence on politicians and oligarchs, and the lack of accountability. The Maidan Revolution, or the Revolution of Dignity as we call it, in 2013, 2014, revealed really how courts were acting not for rule of law, not protecting the human rights, but rather in the interest of the old politicians. And there was a huge demand for change. There was a huge demand for making the system better, more accountable, more transparent, and less corrupt. At the time, President Poroshenko launched a very comprehensive judicial reform, probably the most comprehensive we have to date. We changed the constitution regarding judiciary, went as far as to do so, implementing a number of European standards, also to make judiciary more independent, to make it more publicly accountable, and most importantly, to launch the full-scale renewal of the judiciary, probably the first time in Ukraine's history. That, unfortunately, was not a smashing success. It was quite a good design on paper, but it wasn't very good in terms of implementation. The reasons were twofold. One is the actual inability or unwillingness of the previous government, or the previous president and his team, to actually make judiciary independent. So they made lots of moves, laws, whatever that took, but still wanted to retain control over the judges and the courts. The other reason is more technical, is the composition of the judicial governance bodies. And here I'm talking about basically two judicial bodies. One, it's called High Qualification Commission of Judges, the other High Council of Justice. We have two judicial councils in the country, the one responsible for the selection of judges, another one basically for the disciplinary proceedings. And here we came to a paradox where, like Kalman said, us, the civil society, and the international community were the drivers of the reforms in the last several years, sometimes and very often despite the will of the government, not because of the will of the government. Even though the government declared in many ways Europeization, reforms, transformation, but in many ways there were so many vested interests that didn't go along, but kind of went against the transformation. So the international community was very instrumental in that sense. Things such as visa liberalization action plan that we had with the European Union, because the visa-free travel was and still has a very big symbolic meaning for Ukrainians, and thus very high value for our politicians, the president himself included. There were several steps in that action plan that really propelled the anti-corruption reforms. So was the DCFTA, the association agreement with the European Union, and the IMF memorandum. So really the international community really helped us achieve what had to be achieved. But at the same time, there are a couple of things regarding judiciary, regarding international standards on judiciary, that did not help and do not help to this date. And I'm talking about two principles. One is the irremovability principle of the judges, and the other one is self-governance. Unfortunately, still, the institutions of the EU and the Council of Europe see Ukrainian judges as the judges and not as organized crime as it is in many cases. Of course, I'm not talking about all the Ukrainian judiciary, but In many cases, it is like this. Let's face the truth. And by implementing it, by granting these people the highest standards of judicial independence, we all contributed, both the Ukraine as a country and the international community kind of pushing Ukraine that way, to incorporating that problems and making basically the irremovability and self-governance of the organized crime instead of good governance of the judiciary. Just to give you one example, there was one judge who underwent this qualification assessment or qualification evaluation that every judge has to undergo now. And she came to this panel of the High Qualification Commission of Judges with all these majority of judges elected by judges and the professors and the others sitting there. And she's asked, where did you get your 400+ square meter house, 5 apartments downtown Kyiv, the capital, and 2 land plots, which you could not have earned we could see in your declarations, you have not earned in your professional life as much money. And she goes, as a student, I went to German Democratic Republic, so East Germany, back in the days, and I picked up berries and I did some other jobs, and they gave us free lunches, so I saved some Deutsche Mark, and I brought them back home, and now I bought all this property with that. This is a ridiculous explanation, but it went very well with the commission. So just to give you an example, and it's not the only one. Moreover, then this lady was selected the member of the High Council of Justice to select and discipline other judges. Can you imagine how, and she's not the only one like this in this body. So this was kind of the problem, and still is the problem of Ukrainian judicial governance, that we, before cleansing the system, granted it with the super high standards of independence, and now we're trying to kind of wrap our head around how to make it better. But there's also good news. And there's a counterexample of the establishment of the anti-corruption court in Ukraine that was already mentioned today. When we saw that judicial governance of majority of judges elected by judges doesn't work, at the moment at least, we said, listen, let's create one judicial institution, but let's make it differently this time. Let's include, or let's invite 6 independent experts from European countries, from the other Western countries, that they sit there at the panel and they have an authority to terminate the participation of the dubious candidates in the process. If you make an explanation like this, you're out of the system, you're out of the competition. And it worked. We created the new anti-corruption court that now, the selection process of which differed day and night compared to what we had for the new Supreme Court, which never became new, unfortunately. But also now we see the quality started working in September, and it already issued first decisions, actually first verdicts, and it's really different from the rest of the system. So now we see how we can progress, and now we want to scale this success story to the other courts. And now President Zelensky already introduced a law that was voted recently that scales this, and that includes the international experts in selection of the new judicial governance bodies, that effectively relaunches the judicial governance bodies and invites the independent international experts from the EU, from US and Canada to be there. Now, there's another problematic part of this law. It relaunches the Supreme Court again, for which which wasn't successful, but which is very critically assessed by the Venice Commission. Today we're expecting the full text of the Venice Commission opinion on this law, but we already know that it will be very critical towards another relaunch of the Supreme Court. And there's a debate now in Ukraine whether we should or should not do this, because the Venice Commission said, but the law is already implemented. And it's quite controversial to let you know that unfortunately still not, this law, as any of the laws that are adopted recently in Ukraine, is not perfect, but I think it's a step forward. And right now we're trying to kind of find common ground. We'll see how our government reacts to this Venice Commission opinion. But what we think is really that relaunch of these judicial governance bodies with the help of the international, independent international experts can be a breakthrough. Now, probably the last point, also good news that I have to make, is the IMF Managing Director statement the day before yesterday that was released that she had a conversation with President Zelensky, and they talked about the new program of $5.5 billion in the next 3 years, and that will have rule of law and the independence and integrity of the judiciary at its core. And definitely in Ukraine, this is the first time that IMF, which was, by the way, very instrumental in the establishment of the anti-corruption court, is looking directly at rule of law issues and the integrity of the judiciary. And in this way, Ukraine kind of becomes the test ground for international fight against corruption, which, by the way, today is the day of the International Day of the Fight Against Corruption, if I'm not mistaken. So it's also very symbolic, not historic, but symbolic day today. So yes, Ukraine may become, and is becoming in a way, kind of a test ground for the solutions for the other transitional democracies that might work. And we see that at least the direct international involvement in the selection of the judges works in Ukraine. So I must say that I'm hopeful for this stage of the judicial reform, which is not without the nuances, but it is there. But I'm also hopeful for the next steps, which I think when IMF, with their 5.5 billion euros dollars that Ukraine really needs in the next 3 years, is looking really close, then we really have a chance of transforming it. And I think I'll stop here, and I really looking forward to your questions and the discussion. Thank you.
Thank you, Mihailo. It's been yet another fascinating presentation with a strong emphasis on implanting the islands of cleanness and develop the rule of law system from there. And we understand that Ukraine is a large country, very complex country, a country with a very serious conflict in its eastern borderland. So the complexities here couldn't be larger. I don't think anybody has a clear answer of how to implant rule of law, but Mihailo's presentation and the strategy behind the presentation that he has been following since 2014 with extreme impact is, again, particularly being such a young man, so it's been extremely impressive, and I hope that this strategy is going to work, and if it does, it indeed instructs a much broader audience of how to do these kind of things. Now, the next speaker is Eka Oniani, who is working in the USAID promoting rule of law project in Georgia, and he's representing a country with a different, how should I say, model. And Gia already mentioned part of it. At the time of the Rose Revolution, and I should say until the time of the Rose Revolution, Georgia was within the former Soviet Union the country with the largest propensity for organized crime. In fact, in the former Soviet Union, 50% of the leaders of organized criminal networks came from Georgia. So, but that was then, and the government after that has improved. Has eradicated organized crime after 2003 in a way that Georgia's governance indicators far exceed many new EU member states' governance indices in a very, very effective way. But as Gia mentioned, as a certain arbitrariness still remained there, and there was hope in 2012 with the change of government that piling on the previous successes, you will create independent judiciary, which would really have been the best of worlds. So with this introduction, I'm asking Eka to present the very complex picture of Georgia now and what to hope.
Thank you very much for introduction. It's an honor for me to be here and to listen to great presentations of two other countries. That's very interesting for me. And I hope that a brief information I will share with you about Georgia and especially about Georgian judiciary system development during the recent years will be also interesting for the audience and for other experts from Moldova and from Ukraine. Rule of law is essential, as you know, to accomplish the goals of sustainable development of the country. The role of the judiciary in strengthening rule of law is vital, though judiciary alone cannot do that. It cannot be responsible for that. First of all, it must be a political will, and all three branches of the government should be striving for that. There is no perspective of sustainable development absent the rule of law. In 2016, the Venice Commission published a checklist for the rule of law, which means that the law must be accessible, clear, and predictable. Legal disputes should be resolved by the exercise of the law and not the exercise of discretion. The state must provide an effective way of resolving these disputes. The procedures provided by the state should be fair. It means that the right to a fair trial should be exercised. Laws should apply equally to everyone. Powers of government should be limited and should not be exceeded. And fundamental human rights should be adequately protected. On the next slide, I will show you the recent rule of law index of, sorry, not that visible, I guess. Where Georgia is, it's a bit, the score right now is a bit lower than in 2016. But when you go through all components, unfortunately, they are not that visible from the screen, but the last two are related to the justice and judiciary. That's why we all concentrate about judiciary. It's been a hot topic in Georgia during the last years. 7 or 10 years, or all the time, maybe. While an independent judiciary does not itself guarantee the rule of law, without an independent judiciary, there can be rule of law, as I already mentioned. Politicized, political judiciary is not capable to provide the fair trial and unbiased decisions, thus not able to contribute to a country's development. No fair trial, no public confidence in the judicial function, and no rule of law. Let me show you how the Georgian judicial system looks like. It has been mostly like that. The Supreme Court is on the top. Then we have two appellate courts in West and East Georgia, and then come the city and district courts as the lowest level courts. And separately, there's Constitutional Court, which is dealing with constitutional disputes. The role of the judicial critical contribution to the strengthening of the rule of law and functioning justice system should be provided by judicial leadership. The judiciary can and should strengthen the rule of law by defending its independence, open and accessible justice. Here comes the essential role of the judicial leadership, who should ensure proper functioning of justice system and safeguarding its independence. In Georgia, the constitutional body, which is responsible for judicial leadership, is High Council of Justice. It's a constitutional body which develops proposals for judicial reform, selects and nominates candidates of judges, now including the Supreme Court justices since the constitutional reform since 2018. Organizes qualification exams for the future judges, defines the specializations of the judges and courts, defines the administrative structure and staff of the common courts, and initiates disciplinary proceedings and dismisses the judges. As you see on a slide, it consists of 15 members. There are 9 judge members, 5 members are elected by the parliament, and 1 member is appointed by president. In Constitution, we have a paragraph which defines judicial independence and sets the guarantees for judicial independence of individual judges. A judge is independent in his activity and is subject only to the Constitution and law. Any interference in a judge's activities in order to influence his decision is prohibited and punishable by law. All acts that restrict the independence of a judge are void. That's what Constitution Article 63 says. Further guarantees are given in the organic law on common courts, including some social and legal guarantees. Protection of judges, though there are still some concerns that the judges express concerning the level of support or remuneration, especially considering their excessive workload during the last years. I will try to briefly speak about the recent developments since 2012 until now, because as already mentioned, we had some challenges in 2012 when major changes, political changes happened, and after elections, the elections brought the new government, new ruling party into power in Georgia. Since then, we had 3 waves of legislative reform carried out in the name of making judiciary free from political influence and increasing independence of individual judges. As stated in a number of reports by local NGOs, international organizations, also political players, there was an urgent necessity to increase transparency of the system, reduce power of the chairman of the Supreme Court, which used to be very influential, limit the rules of transferring judges from one court to another that used to be a way to influence them, improve rules of selection and appointment of the judges, as well as procedures of judicial discipline, and change the rules of forming High Council of Justice, and it also changed the rules of its operation. I just want to add that until the first wave of reform, which happened after 2012, the members of the High Council of Justice was comprised of the members who were there, actually political players, members of parliament, and so on. So that needed to be changed. The first wave really brought some important reforms. The politicization of the High Council of Justice happened. Now it is composed of politically neutral persons selected through a competition, instead of including government officers and party appointees selected by the parliament like it was previously. Self-government of judges was increased. The Chief Justice has no power to nominate High Council of Justice members anymore, and judges themselves have the voice in judicial administration. And more transparency was introduced. However, in 2017 report of the Coalition of Non-Governmental Organizations in Georgia for Independent and Transparent Judiciary, we read the following about the first wave of the reform. The concern is that implementation of the first wave of judicial reform was an important phase for empowering the judicial system and individual judges. Most part of the reform was based on recommendations developed by civil society. However, the research shows that despite many positive changes made in legislative framework following the 2012 parliamentary elections, the authorities have failed to demonstrate a strong political will for making any meaningful and consistent changes in the judicial system. In the process of implementation of the reform, the political system refused to fully give up its leverages and gradually made concessions and to dominating and influential groups in the judicial corps. The High Council of Justice failed to protect the judicial system from external or internal influences, while its decisions often posed a threat to independence of the judiciary. As a result, no meaningful safeguards could be ensured for independence of judges, and the system encountered new challenges. That's what, as I said, we read in the report of a coalition of NGOs in 2017 report. That's after the first, because of these concerns, we had the second wave of reform. It was the main characteristics of this reform was that a 3-year probationary period was introduced for the judges, because from now on we had a lifetime appointment of judges, the first time in Georgia. That was exactly the time when the process of implementation of this constitutional provision about lifetime appointment was launched. The second wave also introduced evaluation criteria and procedures for the selection of judges after their mandatory probation 3-year period, which we didn't have before. This aimed to ensure the evaluation process would be objective, fair, and impartial, and at the same time provide legal guarantees and protect judges' interests in this process. So there were further improvements in certain directions, though new concerns were arised, of course. After second wave of reform, we read in the same report, in a sociological survey with participation of judges and former judges, lack of foreseeability of the system of disciplinary liability was named as a possible leverage for influencing a judge. According to survey, other factors that may influence a judge include the institution of court president, concentration of important powers in the hands of the High Council of Justice, lack of social welfare guarantees, and ambiguity of the mechanism of promotions. According to the research, most judges believe that improved independence of the judicial system is the biggest gain following 2012. They also believe that the judiciary reforms are worthy of recognition. In 2017, we had the third and we can say the biggest package of amendments in the legislation, which is called the third wave of reform. It brought improved procedures for the appointment and disciplining of judges, not perfect, but improved. Improvements in the operation of the High Council of Justice, the authority to start disciplinary proceedings this time was brought out of the High Council of Justice and was given to an independent inspector, a new institution created under these new amendments. Completely new system of electronic and random case assignment was introduced and implemented in judiciary. Before this electronic and random assignment of cases, it was up to the court presidents to decide who would be the judge to consider certain case. And as you might understand, that there were lots of concerns regarding how these cases were assigned to the judges. So it was one of the best parts of the 2017 reform to introduce this new case assignment software, actually. And publication of all court decisions became mandatory finally in Georgia, though it took 2 years to implement this amendment, and online database was created quite recently in summer 2019, and some court decisions are still being uploaded because it's very time consuming, as the High Council of Justice states, and it will take some time until all the decisions appear online freely and publicly to everyone who is interested in. Some more transparent rules of the assignment of judges were implemented. However, civil society has criticized last-minute changes to the third wave reforms, which, as they state, benefited elite judges who have undue influence within the judiciary. When the last-minute changes are mentioned, it means that the package which was in the parliament for more than 1 year, the package of the amendments, were sent back from the plenary session of the parliament in the end of 2017 to the legal committee, and there were some amendments made into the draft amendments, and then just the second day the plenary session at the plenary session, the MPs voted for that, and some changes that were made last night are believed to be beneficial for some groups of elite judges within the judiciary. What challenges and areas of concern we had after that? Judiciary usually complains, judicial representatives usually complain mainly about heavy caseloads, and it's really huge. It can be viewed as the main reason for they believe that it is the main reason for the negative opinion about Georgian judiciary. Those factors impede the ability of judges to fully consider the merits of cases, prepare individualized opinions that fully express the reasoning for their decisions, and to deliver justice. Sometimes some cases, it takes 2 years until the first hearing date of the first hearing will be set by the court after submission of the complaint. Sometimes it takes a couple of years until it goes to the second instance. So of course it affects not only ordinary citizens but also big businesses, for which the judiciary recently, just 1 years ago, a little more, they created a separate chamber within the Tbilisi City Court, which is the biggest court in Georgia, which deals with commercial disputes, expensive disputes. So the judges who are in this chamber they deal only with this kind of cases, so they are not busy with other types of cases, and that's better for business, as it's said, to complete their cases faster than it would be if ordinary judges would deal with it. Though there are some concerns regarding how composition of this chamber is decided. On the other hand, civil society has another concern about undue influence of the judges, which they call claim of judges. So I tried to briefly give some information about the recent years and what happened in 2019. As I mentioned in the beginning, after big changes into our constitution, the right of nomination of Supreme Court judges was given to the High Council of Justice following these amendments. Before, this right was given to the President of Georgia. Also, the Constitution said that the number of the Supreme Court judges should be not less than 28. Before, the maximum number of Supreme Court justices for the last 10-15 years was 16, which was decided by the plenum of the Supreme Court. But in reality, right now, we have only 8 judges at Supreme Court, which means that there are not 3 complete chambers at Supreme Court. We need 3 of them in the administrative chamber, 3 of them in civil chamber, and 3 of them in the criminal chamber. But unfortunately, there are only 8 judges left at the moment. So according to new constitution, there should be at least 28, and the organic law says that they should be 28. So we had the competition announced in spring 2019 after the scandal which Professor Giannotti already mentioned. The scandal was that to fulfill the requirement of constitution, the High Council of Justice nominated 10 members, 10 candidates for the Supreme Court in December 2018, which was in compliance of the law, which set no rule about such nomination at all, other than they should be nominated by High Council of Justice. So there was no procedure on that. After that, a big scandal was caused by this nomination, which ended up not splitting, but with leaving of some members of parliament from the ruling party. And following that scandal, the ruling party and parliament decided to work on new rules how these judges should be nominated. You can understand how important it is to have 20 new judges at Supreme Court, while we have only 8 right now. So it's a dramatic change, and those 20 people will be appointed for lifetime. and it will really be very important for the future of Georgia, future of judiciary and future of rule of law. Then those 20 candidates who are now in parliament and who will be voted the day after tomorrow, when I'm back to Georgia, and on Wednesday morning, they were selected through the competition, though there was a lot of concerns regarding their backgrounds, their financial backgrounds, their educational backgrounds. The diplomas of some of the candidates were even questioned. This is where we are now. In 2 days, we will probably have the results of the voting of the 20 new Supreme Court justices, and we will probably have till the end of this year or beginning next year the new wave of judicial reform and parliamentary elections in 2020. Thank you.
Yeah, but it was good. Thank you very much, Eka. Very, very interesting presentation. Also, it's probably the situation is different, but it's interesting to compare the two presentations in one aspect that Mihailo showed a very high skepticism towards the ability of the judiciary to clean itself if it's too much of a managing body, while in Eka's presentation, I guess there was more hope towards that. It may well reflect also the differences, because one gets the impression, and I might be wrong, but this is my strong impression, that with everything, the Georgian judiciary has gone through changes already in the previous political period, as well as the new wave of reforms are not meaningless. I don't know if we have a breakthrough or not. I would be inclined that, at least in the politically non-sensitive issues, we do have a breakthrough in terms of independence of judges, but it's really up to further investigation. Also, there is now a body of evidence, empirical evidence, that shows in these countries, most importantly in Ukraine, there was a research, very in-depth research in detention centers and also in the prosecution, that shows that one thing is the law and the other is the implementation. And the practice follows more, in that particular case, I'm not generalizing it, it follows more the tradition than the letter of the law. So there is plenty still to dig in, and I think Eka's presentation has been extremely rich to show that we are dealing really with a very, very sophisticated set of issues under the label of moving towards rule of law. So with that, I would like to ask Julian Rusu, who has a Magister Juris degree from the University of Oxford, and he has been for a few years the principal rule of law expert of the Institute for European Policies and Reforms, a very prestigious outfit in Chisinau. So, Julian.
Let me quickly find my presentation. One thing is certain from what I've heard today, is that many of the problems are common to the three countries, and those relate to the genuine independence of our judges, and also the justice system generally, and also the great negative impact of the vested interests, particularly coming from political parties and their leadership when it comes to the independence of the judiciary and of the justice sector, which is, according to our constitution, one of the three powers and should be independent. I'll first of all present a brief background of what has been happening in Moldova in the last 10 years or so. We have developed a justice sector reform strategy back in 2011. It was initially set for 2011-2016 and then extended for another year, with plenty of actions, lots of new legislation related to the prosecutorial service, the self-management, the competences of the self-management bodies such as the Supreme Council of Magistrates, the Supreme Council of Prosecutors, also a new map for courts. We have reduced significantly the number of district courts, and thus the general idea was to increase the capacities of the district courts to examine cases. This reform, however, is not seen unilaterally as a positive one, because we are on one hand reducing the number of courts and increasing the capacities, but on the other hand we reduce the distance between the citizens and the courts. And also at some point it's quite complicated to ensure the specialization of judges, meaning that if you have committed, let's say, a misdemeanor somewhere in the southern part of the country, you have to travel to a city which is 50, 70 kilometers distance. And this poses questions related to how effective the reform was in terms of restructuring of the courts. That is not valid for the case of the capital, because there you have a large concentration of citizens and a relatively short distance, so that worked quite well. We did not accomplish one of the key provisions of the strategy, which was genuine independence of the judges and of the prosecutors. The prosecutors are still not magistrates. We tried to follow the solution, the French solution of total independence of the prosecutors, and we are still having this probation period of 5 years when the judges are appointed, and then they receive a lifetime appointment. And this is consistently seen as one of the key problems related to the independence of the judiciary and of the judges individually, as they are dependent on the proposal from the Supreme Council of Magistrates to be appointed after 5 years, and it is the president of the country who issues the decree in that respect. As in Ukraine and probably Georgia, corruption is seen as one of the key problems of the societies, has been constantly highlighted as one of the three key problems, and I'm afraid numbers are not regressing, much rather stable or even increasing. Although we have a specialized structure such as the National Anti-Corruption Center, and there is a specialized prosecutor's office which focuses on anti-corruption cases. In terms of political structure, my colleague Andrei Popov already briefed you quite well on how the tilt on one, the majority tilts in favor of one group of political parties on the other. So we had this fragile majority between 2009 and 2014, and after that, with the unraveling of the stolen billion scandal, there was practically a political carnage, so to speak, where one political party took over many of the MPs of another party and essentially created a de facto majority. This period is also seen very dangerous from the perspective of the judiciary and independence of the courts and of the prosecutor services, because it was during that time when we created specialized prosecutors' offices, and they have been used on many occasions as a tool to fight against political opponents. So back in 2016 and until 2019, and now the data shows, because it was revealed recently, there have been a lot of illegal tappings of phones and also surveillance of homes of prominent members of opposition political representatives. This is clearly not the direction the country wanted to see with respect to the justice sector development. One of the critical elements that also became public after that was how the political parties back in 2010 decided to split the political control. And this is really outrageous, because you cannot talk about separation of courts, prosecutors' offices, when these institutions ab initio should be independent. Yes, you can divide agencies, ministries, the cabinet, but you cannot touch such structures, because this is a different branch of the power. And this is what we've seen when data was revealed on the secret annex of the coalition agreements. This in turn generated a very dangerous precedent, whereby political parties have decided that, well, when this was done in one political structure, it could be done after that. So we're in a position to fight yet another dangerous precedent and take it out of the current practices. What we've also seen with respect to the judges and prosecutors is that the electoral process was actually not very competitive. And the members, judges and members, prosecutors of the two Supreme Councils were approved having, surprisingly, the same number of seats. So there were exactly the same number of candidates as there were the number of seats in those two councils. Unfortunately, what we're seeing is that there's no genuine competition. And I'll get back to the legislative amendments with respect to the electoral campaigning period, which should be a normality in the case of judges and prosecutors, because they're electing their representatives for 4 years. Also, what we've seen after 2016 until 2018 is conviction of some political figures. So the justice generally was used to get rid of political opponents. I've mentioned about the stolen billion scandal. Well, some of the leaders of the pro-European coalition was actually imprisoned. We have very fresh news that he was freed on probation last week, and his first visit outside of the country is to be Hungary. Mr. Orban gave him a nice invitation, at least this is what the press is saying, so more on that to come. Another prominent actor who was more seen as the chief landromat, or the comandante in jefe in terms of landromat cases, Mr. Platon, was also convicted, not with the participation of the Ukrainian authorities, because it is there in this country where he was seized and then sent back to Moldova to be trialed. There are numerous episodes related to the so-called Russian laundromat. I'm sure you have heard of it. And we, unfortunately, were part of this process. And judges, bailiffs, bankers were involved in this nasty process. This fragile majority, which Andrei mentioned in greater detail, set to touch upon very important aspects of the justice sector. Well, first of all, it initiated the process of reform of the Supreme Court of Justice. It's both transformation in terms of reduction of functions, creating a genuine cassation court instead of a court that revises the facts of the cases, which further developed into an extensive, extraordinary vetting procedure based on the Albanian example. So that was launched as an important idea to verify the ethics, the integrity, and the professionalism of the justice sector. And this came because we had numerous cases, some of them very prominent. I'm sure Kalman heard of a couple of those, such as one judge declaring purchase of a Porsche Cayenne worth 500 euro. Well, I'll tell you one thing, I want 20 of those. Obviously, you cannot find them on the market. And she justified it by the fact that she bought the car without the engine, which is total gibberish because the car is registered based on the plates of the engine. And you cannot register otherwise the car. It comes as spare parts. So again, some judges think that all the members of the society around them are just foolish and don't know the details of the registration process. We had other cases related to our integrity system. Since 2016, judges and prosecutors and many other public officials are obliged to publish, to present their statement of income. And the statement is public, with the exception of personal data information, such as names of family members, exact address of the real estate, and other aspects. Well, guess what? Some of the judges, which are very fresh and have only 2-3 years since appointment, declared that they collected 100,000 euros as donations at their wedding. Nice relatives. I want a couple of those. And the key question to me is, who was at that party? I'm sure other judges and prosecutors, maybe bailiffs, were also part of the party. So if this is true, my question is, did you donate your entire monthly income, or maybe income for 3 months, just to go to one party and then starve for the next period? Obviously not. So there are serious questions related to how they use the property. There's a lot of dirty money running around in the country, and there's a sense of impunity with respect to the judges, particularly those who have offered the necessary services to the political elites. Having this magnitude of the reform and some of the political establishment's clear issues of integrity, and I'll just mention one, Mr. Dodon's campaign in 2016 was covered with lots of questions on how he financed his campaign. And the scheme was very simple. There was a company from Bahamas that lended money to a Moldovan company, and that Moldovan company that lended 500,000 Moldovan lei to 10 members of the political party. Obviously don't want an independent judge. Each, yes. 25,000 euros each, so it's 250,000 euros just in one stroke, using an offshore jurisdiction such as the Bahamas to transfer the funds. And the money can come from anywhere. I mean, smuggling of drugs, weapons, people, children, you name it. You don't know the source, and you don't know the effective beneficiary. This is how Mr. Dodon financed his political campaign back in 2016. Actually, the cornerstone of this vote of no confidence, I can't even call it a vote of no confidence. It was more about saving your own skin, was related to the appointment of the Prosecutor General. The key idea behind it was that if you don't have an integral person that would lead the Prosecutor General's office, then you cannot possibly instrument cases which are essential to clean up the judiciary, but also the political parties themselves, because they gain power sooner or later. This is their karma. And because the competition process was rigged, essentially, with some appointed members giving disproportionate figures to candidates and favoring a particular candidate, that led to this bold decision to take government responsibility and expect support from the parliament, which did not happen. You realize that with those important elements not happening, other critical elements such as reform of the penitentiary, conditions of serving the sentence, which may be inhuman or degrading, or the length of procedures in courts or other aspects, they're all unfortunately on hold. I'll switch directly to the to-do list because I'm done, almost done with my time. So I'm done. So then I'll take 30 seconds to conclude. I'll demonstrate it by using only 30 seconds. You can see it, there's a long list, but most importantly, we should do our homework, irrespective of what happens at the political level. And this is developing the vetting system and using the Albanian light version, do the bylaws and regulations, ensure that the new members of the self-governing bodies are elected based on a campaign period of at least 1 month to support the agents of change within the system, because there are quite a few. And also do awareness raising and advocacy, and also work with the international partners and community to explain in very simple terms what is happening in Moldova. That would be from my side. Thank you very much for your kind attention. I look forward to your questions. Thank you.
Thank you very much, Julian. And I also demonstrated the complexity of rule of law because I actually enforced it only on you and not the other speakers, although there was some self-reinforcement here too. I think these three excellent presentations really have shown how much complexity in this issue is. The remaining time is short. Noemi said that we can run until 1:30. So instead of talking much, I would like to ask the audience if you have questions and comments. Marina, what are we have over there? Excellent.
Good afternoon. My name is Marina Vortnyuk. I am a researcher based at the Central European University here in Budapest, and I've got a question to Mihailo. To start with a footnote, I'm not working in the field of the rule of law. That's why I'm seeking for your professional expertise on this issue. So if there is a takeaway from today's conference, for the people who are not really experts on the rule of law, what is it? What is it in your opinion? I mean, again, it's on Ukraine. We've got a new government since several months. So and I felt that you are trying to be balanced in analyzing the situation, showing that there are shortcomings, there are things, there are gaps that to be filled in. On the other hand, you are saying that there is place, or let's say, for moderate optimism, if this is my correct impression from what you were mentioning. Is that so? Is my impression correct? So I myself, being a political scientist, I used to use the expression that there is a mixed record of the government. So again, trying to be balanced to show that everything is far from perfect, but there is room for optimism. So thank you very much.
Thank you, Marina. This gentleman here. and also introduce yourselves.
My name is Joel Szabo. I'm Associate Professor of Constitutional Law at the National University of Public Service. Thank you for all these very comprehensive lectures. I'd like to hear maybe just a few words, because this could be a topic for another conference, about administrative justice in these countries. It was quite an issue recently in Hungary that the government introduced a new system of administrative judiciary, which was recently taken back. So it would be interesting to know how judiciary can control administrative actions. And maybe a second one on the follow-up of all these, the role of constitutional court, whether or not it can impose some kind of control of government actions, or constitutional court, I mean, constitutional adjudication is purely about normative control, or is it also possible to attack a decision by the court at the constitutional court?
Thank you very much. It's a question to each of the three. And I think Gia is, sorry, I didn't see, but then I will also give the floor to the lady in the next round.
Yeah, okay, I have a question to Eka, not surprisingly, but maybe others also want to react. Okay, you spoke about 3 waves of reform, but there were several other waves of reform under the previous government and actually under Shevardnadze government. All of them were following generally kind of international recommendations. All of them were considered good and steps in the right direction. And here we come when we had the major political scandal again about judiciary, as we both mentioned, and there is very deep skepticism in society, which includes not just opposition, who is supposed to be critical, but also kind of expert society, that judiciary is not independent, basically. That, for instance, you said that High Council of Justice is now unpolitical in the sense that there are no politicians, so they would be politically neutral, but people say they are not, because there is this kind of informal clan, and through this clan, government exercises some kind of informal influence. So that creates some kind of cognitive dissonance for me, that there were so many so good reforms for 20 years more or less, and then we come here and we say, oh, the court, lack of independence of courts is one of the gravest systemic problems, so how come? And one of the possible questions that rises in my head is that maybe some of those expert advices from European partners were not so good. Mihailo said this actually, right? That maybe they have good intentions, but they don't understand our local conditions, let's say so. So many people are, it's considered, for instance, that lifetime appointment of judges, it's a very good thing because it increases their independence, but quite a few people in Georgia have become quite scared that judges who are considered kind of notorious for their past, not very principled behavior, now will become lifetime judges, and you cannot do anything about them. So can we actually dare maybe to question some of best recommendations that we get from our best friends?
Yeah. So actually, let me ask the speakers to answer. But let me preface it that this cognitive dissonance is actually 2. One is in your example. One is indeed that we hear also in Moldova, there has been a reform, 2011, 2017, Julian mentioned. So by by the bureaucratic processes, there is always a reform period. And yet, the breakthrough is not coming. One of the issues is here that the internationals, lacking the context, don't fully take into account, and sometimes also their local NGOs, yes or no, that a reform on paper, it's not a reform in reality. So when you think about reform, you also have to think about the role of the law within the whole social fabric. It's not like Netherlands, so it's not a firmly set rule of law situation, and therefore when you design the reforms, you cannot assume that a law will be implemented, and very often it is not taken into account. The other is a dilemma which I try to highlight between the talk of Mihailo and Eka, and also I think this dilemma appeared in Julian's speech. So on one hand, given that the setting is such, Mihailo believes strongly that you cannot leave the process to the self-government of the judges, because it will never happen, since they are part of criminal mechanisms, criminal organizations. On the other hand, Julian says that when it's left to the politicians, they will follow the political logic and appoint and guide people and bodies according to their own political interests. So I think it's a real very big dilemma, and that's why rule of law reform is very difficult. And by the way, John mentioned at the beginning that we have a new wave of young reformers, and this panel, except me, is an embodiment of that, that thesis. Yeah, but it's a very difficult, and we only really mentioned or analyzed or started to analyze the judges. To some extent, we went to the prosecutors, but then there is this whole big area of police and police action towards or against the rule of law. I would like to ask Julian to start, and then we go here. And I also would like to say that given that the Hungarian gentleman's questions were open-ended, still try to be very brief in your reflection, because of course these questions are such that they can invite very long presentations as well. So Julian first.
Thank you. On the administrative justice, we have a new code since April this year. It's an attempt to harmonize legislation on procedure and also rights and timeline during which you can address the court for an administrative case. Because I'm also a practitioner, I have a case that runs for 4 years, and because of the new administrative code, it was sent to a new judge. Just to explain to you the efforts that relate to the administrative justice and approval of new legislation may also have some sided effects, which is us starting the case from scratch after 4 years. The Constitutional Court does not have a mandate to review cases, but after a decision of the Constitutional Court interpreting the Constitution in 2013, attorneys can now challenge the constitutionality of provisions. And that means that the court has to react quite quickly in 15 days, and then present its opinion whether the contested provision is constitutional or not, and then declare and issue an opinion on that. And based on the outcome, then the court that is reviewing the case has to adjust. It's somewhat similar to the preliminary ruling that there is at the EU level, but it's only related to constitutional matters, and you have the Constitutional Court and all the district courts or the Court of Appeal or even the Supreme Court of Justice. At any stage, you can challenge the constitutionality of the provisions, and usually that relates to the criminal code provisions or the procedural legislation. On the EU experience, obviously you need to have local context. And it is essential when you formulate and then use the recommendations to, first of all, do the sequencing of actions. That's critical, and that was the key problems of our strategy, the way it was implemented. The sequencing was not followed. And unfortunately, some recommendations are good at one time, and then they're not good anymore at another time. And this was our case. We had a good package of judges, Integer, back in 2009, and we got completely lost after 10 years. You cannot give them now a lifetime appointment without vetting them. The situation has changed dramatically, so you have to apply and adapt the recommendation based on your internal circumstances.
Thank you very much.
Thank you. To save time, I will just explain that we have the same kind of system as Julian has mentioned in Moldova. Constitutional Court's competency is almost the same. Not only individuals can address Constitutional Court, but also the judges can address it in case they see that there is some provision in a law or some regulation is not in compliance with the Constitution. Actually, that's how it works. I would like to confirm what the impression you had, Professor Nadia, is exactly what you had to have. It should cause the cognitive dissonance that we went through all these reforms, and not only these reforms or so-called reforms during the last years, but for the last 25 years, and we are still somewhere, not maybe still there where we started from, but we are still having challenges, having problems. The trust towards the judiciary is still low or becoming lower. In the index, rule of law index, we are now behind. The score is lower than it was in 2016, so what is the reason? Maybe it's logical that when we address one problem, another problem arises. For example, when Georgia constitution introduced lifetime appointment of judges, partially based on international organizations' recommendations. We agree on that. It was criticized by some Georgians, but it was considered as a guarantee of judicial independence, individual independence, because that time we faced how many problems the term of office caused for the judges. But on the other hand, what we can name as a problem now with these lifetime appointments is that there is lack of accountability of the judges towards the society, because actually there are no precedents when the judges are disciplined for certain misconducts. The number has decreased while the number of complaints are quite high. The grounds for judicial discipline are still not clear. So it's not up to the rule, but up to the discretion of the special body who will discipline the judge to decide whether the certain misconduct is misconduct that requires a discipline or not. So this is another problem now. What we as representatives of international organizations or locals or NGOs are criticizing that needs to be addressed. But then another problem will appear, because all the time the lawyers maybe, as we say in Georgian, find a way to find a gap and to go through that and to use that gap. Self-governance was increased. It was increased indeed, but on the other hand, now we got a system which is almost closed. We have up to 300 judges in the country now, while we need, according to surveys, we need more than 400. There are competitions all the time in the High Council of Justice, and the number is not increasing. The judges are moving from one court to another, and new blood is not coming. So what is the reason for that? How can it become, how individual judges can become more independent if there's no new blood. So if they are closed and if they discipline each other and if nothing happens, it is indeed self-governance, but on the other hand, there is lack of accountability and risk of corruption, which is not that visible yet, but there are really many concerns about possible corruption even within the court system, which we were actually proud of that we have eliminated. So I don't know. But this cognitive dissonance was the right words and right feeling you had. Thank you.
Thank you. I'll also try to be brief, answering the question of the colleague from the Central European University. Yes, we're cautiously optimistic, as we call it, partly because we see the results of this current government. Yes, it is not without the nuances, without the drawbacks, without other things, but generally we see many of the anti-corruption reforms being unblocked that were blocked for the last 2 years. We see the lack of the practical absence of attacks on the independent, newly established institutions such as the National Anti-Corruption Bureau that were very active under Poroshenko, the last 2 years of Poroshenko. That is partly, we think, because it's natural, it is a new government and once it shows quick results. But then you also have to consider how new it is. Our parliament is renewed by 80.5%. So 80.5% of people who are in the parliament right now have never been members of the parliament before. So these people do not have, so the new government, the new president won by landslide. So 73% was the president's result in the second round of elections, President Zelensky. And these people, the vast majority of them were never politicians before. So they simply don't have as many vested interests, which is good. Yes, they are not experienced enough. Yes, the situation has a flip side, but the good side of it is that they're not, the establishment and existence of the independent anti-corruption and rule of law institutions doesn't go against their interest, which is good. Two, what will be my outtake of all this? For Ukraine, definitely, and I think, correct me, colleagues, if I'm wrong, but the situation is quite similar in Georgia and Moldova from what I saw from the brilliant presentations today. Integrity first. You have to first ensure the integrity of the judiciary and then comes the rest. I think it was it Václav Havel who said that it's better to have 5 years of mistakes than 50 years of sabotage. We kind of had already 28 years of sabotage, so to say. Now, let us hire new judges, let them be unexperienced, let them be whatever, they will learn. You can teach them law, but you can't teach them integrity. You can't teach it. You simply have to remove the old guard and you have to renew and you have to bring in the new blood. And that I think is the most fundamental thing and the way to go. And then we can introduce the self-governance, then we can introduce all the other standards of design of the judiciary as if it were the independent judiciary we have in the Western democracies. Thank you. Oh, and by the way, just one thing I wanted to mention. Global Solutions, Local Damages is the name of the paper of two brilliant Czech experts back in 2013 who talked about how the Western institutions, how the international institutions went and placed this judicial self-governance, who said basically to the Central and Eastern countries, Central Eastern European countries saying, introduce these judicial councils with the self-governance rules and then everything will come and it will be brilliant. It doesn't. So first you have to cleanse your judiciary, then you have to introduce these high standards. And even the Venice Commission lately says, I think it repeated it in interim opinion on Moldovan judicial reform. It repeated its own opinion on Albania, saying that in the countries like Moldova and Albania and Ukraine, for that matter, introduction of such high standards to the judges who are not ready to be independent themselves results in a paradox. Thank you.
Thank you very much. There are two more questions that I have been omitting first the lady there, right? You wanted to ask a question? No? No, okay. No? So then there is one, this gentleman here. Because you were running back, so I thought it was...
Hi. My name is Eugene Howe, independent thinker. I'd like to address my question to Mrs. Zernikoff. In the U.S. right now, we're having a constitutional crisis. Now, that constitutional crisis has started in 2016 with the election of Donald Trump. And it seems to everybody that's concerned at this point that somehow Ukraine is involved with this constitutional crisis. And actually, I would call it a coup. But what they're saying now is that the courts in Ukraine has stated that Ukraine didn't meddle in the U.S. elections. All right. Can you speak to the veracity of that court finding? That's my question.
I don't know what to add. President Zelensky is now on a current Time magazine because it's called, the article I think is called Caught in Between or something like this. The man, there we go. We also don't have to not forget that we're also suffering from Russian military aggression. And tonight is also talk on the Normandy format where we're also quite concerned about this, what will come out of it. Yes, it is complicated being caught in both situations like this. The US being the closest and the most important, or one of the most important, definitely, partners of Ukraine internationally, having such a difficult situation, trying to not be partisan, trying to kind of, in such a turmoil, political turmoil that is now in the US, is a very difficult situation. And the court, yes, so this is a depiction. This was the District Administrative Court of Kyiv. This is the most notorious court in Ukraine that has a unique jurisdiction to rule about, it is an administrative court, by the way, to rule about the decisions of the central government bodies, right? Because they're in Kyiv and it's territorially, it's in Kyiv, just a normal district court, but it's there, so hence it has this competence. And the judges there are the most notorious judges we have. And this is the depiction of how, and of course there were vested interests. The previous Prosecutor General, Mr. Lutsenko, was involved in this, who also now is a Giuliani bud. He meets with him very often, and then he was a part of this orchestrated thing in Ukraine meddling in US elections. So these judges are notorious and don't have any values to the extent where they would rule that Ukraine had meddled practically in the US elections for certain reasons. I don't know what the agreement was there. Was there money involved? Was there some other political interest involved? Doesn't matter. For these judges, just throwing your country under the bus like this means nothing. For them, the money and the power and the influence, that's what means the most. And that's kind of a very vivid depiction of what.
Accusation you're putting out here and was orchestrated. That's a very negative legal word. Excuse me.
Sure.
And then you said that Mr. Rudolph Giuliani was involved in this. That's not his question.
I'm sorry.
You understand what I'm saying?
Sure. Right. Let's not dig. You're right. Let's not dig very much into. The question was. I'm sorry if I understood your question correctly.
The question basically. So the subject of the conference, honestly speaking, my opinion, it's off the subject.
None at all. You're talking judiciary. You're talking advance in all your countries, which is tremendous in reality. It shows the similarities. Georgia, Moldova, Ukraine, really looks like most of you are at the same level, going up and being blocked by this, by that, or the other. What happens in the Ukraine is essential for development of all the other countries because it's the biggest one, is the closest one, and it has the biggest riot in the world right now because of the US connection. So I'm sorry, I'll disagree with you.
Yeah, probably not comment on all this. I'm an expert on Ukraine's judiciary, and unfortunately they played a negative role in this. And it's,
Part of the charge of meddling in the 2016 election came about because the ambassador from Ukraine to the United States wrote an op-ed that was anti-Trump. So he declared a very, I mean, he said he's a terrible man and you shouldn't support him. So that was one of the issues, just for your knowledge.
Well, I'll just make one comment. I know Ambassador Jovanovic pretty well. She's been very helpful. She's been very, in my view, okay, I'm just saying my personal.
Speaking of the U.S. ambassador
I'm just,
to Ukraine,
right.
I'm speaking of the Ukrainian ambassador to the United
Oh, there we go.
States.
Let's just not my field of expertise. Let's just stop here. Thank you. Yes.
Yeah, so my question to you is basically the honesty of that court finding. Okay, that indeed Ukraine did meddle in the U.S. elections. That's what we were told in the U.S. And I'm just asking you whether that court finding is credible or not. Because we're talking about corruption of the courts, corruption of the prosecutors, which, by the way, we have in the U.S. as well.
Well, to my knowledge, what court based their reasoning on in the so-called decision on Ukraine meddling in the U.S. elections, even though Russia obviously had much more to do with meddling in the Ukraine, if there was something on. So there was a Paul Manafort case, right? So there was the so-called black ledger of the party of the regions in Ukraine. So there were things that relate to the people connected to some of the politicians who are big politicians in the U.S. right now. In this way, you could say, I don't know, investigating anybody who is remotely connected to somebody can constitute as meddling in the elections. This court, my point is, this court doesn't have the competence to find facts.
That's the answer.
That's the answer.
Thank you.
It can't do that, but it's still ridiculous.
Thank you very much. Yeah.
Thank you very much, and thank you very much for this really excellent session. I guess it does show the enormous complexities of moving towards basically rule of law situation from a basically arbitrary justice situation. I also think that that is far from hopeless. I share the measured optimism of Mihailo, as well as I get from Eka's very wise presentation that things and I do believe also that things in Georgia, if we compare now with 2003, there is a tremendous improvement of professionalism, as well as the scope of uncorrupted judgments. We didn't mention the issue of salaries, but really one of the cornerstones of Saakashvili's reforms were to dramatically improve the salaries also in the justice sector for judges and prosecutors and policemen. But, and that is a very important precondition, because if judges and prosecutors are paid very poorly, as was the case, for instance, in the time that I served in Ukraine, particularly for the prosecutors, then it is guaranteed that they will try to freelance besides the salary. But the situation here is far from hopeless, and it's very, very important that we at the European Union have a deep understanding of the complexities of the situation, of the dilemmas that Eka was very candid about, but try to gear our recommendations and also conditionalities to the context. And I trust that this session has contributed to that. I'm sure that Noemi would like to say a few words, and I don't know if Joan, you would like to say a few words.
I just would like to thank, this has been an excellent panel, so was the first one, and I think we can be confident that there, in spite of everything that was said, there has been progress. And of course, these countries will not be like the Netherlands in a short period of time, but I have to assure you that neither will Hungary, unfortunately. And when we read Hungarian authors of about a century ago, like Miksát or Moritz, we also have the impression that not much has changed. But in reality, there have been changes, and if you read Kalman's excellent study about the region, which does not cover the past years, but ends in 17 or 16, you can be convinced that there are indeed a lot of steps that have been taken. And for this progress to continue, you need the help of the European Union and NATO and the West in general. So I'd like to thank you all for your attention, and I'd like to thank to my colleague Ibolya Dan for all her help in the logistical complications that have been around this conference. I think everything has worked out quite well. And I'd like to introduce Enikő Győri, a member of the European Parliament from Fidesz, and thank her for participating and greeting the conference. Thank you.
Ladies and gentlemen, I also would like to welcome all the participants, and well, I will just deliver greetings on behalf of the European Parliament to this conference. Thank you so much for the invitation. It's a bit strange that between the two panels I can deliver this introduction, so please conceive it not so much as an introduction, because you already had a good panel, and you are just about to start a second one, but my intention is just to say hello on behalf of the Parliament and share with you some of my thoughts on these three countries, and in a broader term on Eastern Partnership and what the EU has to do with these countries. Sometimes I have the feeling that we are speaking about three neglected countries. And it's actually quite general in the European Union that we deal with our neighbors, imminent neighbors, or a bit more distant neighbors only when they have their house burning, and I don't think it's the right attitude. And being a Hungarian MEP, of course, for us, it cannot be like this, so we have to be very updated on what is going on in these countries, so this conference is a very important contribution to that. So our best interest is that these countries get closer to the European Union, and we know what they are doing, and we try to help them in their aspirations. We know that it's not an easy neighborhood, but I think we Hungarians, and maybe the other Central and Eastern European countries, understand a bit better what is happening. From Western Europe, this region, let's call region, the 6 Eastern Partnership countries, is far away. So it's very hard for Western Europeans, I suppose this was already discussed here, to understand what is happening and why. And we, coming from a close region, and sharing part of the history with these countries, I think are more sensitive and understand better. So I think the EU should take a better use of the knowledge of, let's say, the V4 countries and maybe even other Central and Eastern European countries. And I think it's a very good news that responsibility for Eastern Partnership, for this neighborhood, Eastern neighborhood, will be in Hungarian hands. Enlargement and neighborhood policy belongs to the portfolio of Oliver Várhelyi, and hopefully having a sensitive person, open person he will be a good mediator between these countries and the EU institutions and the member states, because we have to know that here the decision, what happens with relations with these countries, is in the hands of the member states. So the commissioner can always be a good facilitator, but decision lies with the member states. Let me just quote one sentence from the mission letter by Ursula von der Leyen, the new president of the new Commission, to Mr. Varhey. The European Union's future is shaped and tied in with the future of neighbors and its partners. A stable, secure, and prosperous region around our union is therefore of paramount importance. So this is the mandate. You can say that it's very vague, but I think the substance is there. So it's in our best interest that these countries develop and want to share a future with us. The title of the conference is the European Union, these three countries at the crossroads. Well, the European Union is at crossroads, but I'm very cautious with using this word. And the reason for that is that I have been attending even European Council meetings where we said this is a historical European Council. Historic decisions are due to be taken. And of course, we always take decisions, but if you call every meeting historical, then the term starts losing its real importance. And this is a bit my impression when we speak on the neighborhood policy. Then we have nice words, but the question is whether we can deliver a bit more and what we can do. And I think the record of the V4 countries is really important in this matter. We have quite concrete programs. Hungary in the Eastern Partnership is responsible for helping the Eastern Partnership countries concerning entrepreneurship and SME policy. So something very concrete. We have concrete programs, for example, in the Ukraine, so that we could contribute to the economic development. And I very much believe in these concrete issues because we have to be aware of the realities. And let me just sum up certain characteristics I think these three European countries share and which show that they will be different. So I don't think we can treat them as we are treating, let's say, the real EU candidate countries in the Western Balkans. Meanwhile, they are European. And if we look at the treaties, the only condition for applying for membership is being a European country. 2 out of these 3 countries have clear ambitions to apply for membership. Moldova is, as far as I see, but maybe the distinguished panel members will correct what I'm saying, keeps equal distance among partners. And of course depends on the government, whether ambitions towards the EU or towards the East are stronger. But Ukraine and Georgia are definitely applying for membership. And in general, I don't like speaking in very nice terms and making promises which remain empty. I think these ambitions will never be fulfilled, or not at least in the foreseeable future. Why I'm saying this? Because I think that their geographical position, having a very important and very powerful and offended neighbor, determines the ambitions. And for me, the history of the last, we can say 30 or we can say 5 years clearly show that the important neighbor, former owner, because we can call former owner Russia, is there and will not let these countries go on the other camp. So we can have nice words, but I think reality will prevail. And what we have seen in the last 15 years, I think we have all learned that these countries will not be democracies in the Western European terms. So we can put them conditions. We can help them getting closer in fulfilling the standards, but I don't think that they will be fully fledged Western European standard democracies as we want them to be. We are, in this case I mean the European Union, most European institutions or most member states. As they were part of the Soviet Union didn't let them go. The Soviet Union let certain countries go, but when we speak about Eastern Partnership, I think the Russia will not let go. It was different when we were let go, but we were never part of the Soviet Union, just dominated countries. These countries have territorial problems, which is something which excludes actually any kind of aspiration for membership. And finally, what is a common characteristic, as I see, that even from security point of view, and we not just speak about EU aspirations, but not NATO aspirations, here aspiring for NATO membership would mean for Russia belonging to the enemy's camp. And I don't think that this security risk Russia will ever permit. What happened in the Vilnius Eastern Partnership EU Summit, it was in November 2013, when actually we forced Ukraine to choose between two realities, the European Union and Russia. And I'm not sure whether it was very wise, because we know very well what happened in 2014. And I think, yes, there is a correlation between what we were pushing for, where Ukraine was running, and we were unable to offer an option to reconcile a free trade agreement, a deep and comprehensive free trade agreement with the European Union, and remaining very glued ties and maybe free trade with Russia. So we were pushing just for the one, and we were not really understanding the geopolitical context of this choice, and the consequence, as I see it, was the occupation of Crimea. So all this proves that what we are speaking about is an extremely complicated neighborhood. Of course, for Hungary, is, as I've already said, it's not somewhere in a distance, but it's our imminent neighbor, where we have Hungarian minority living, and for us, it's vital that they could enjoy the rights they have enjoyed before. Acquired rights is a commonly known term in the European Union. Actually, it's very sad that there is little sympathy among NATO members that we cannot do more for Ukraine unless we can guarantee rights for this minority. And of course, Ukraine is an important transit for our energy supply, a transit country for our energy supply. So it would be in our best interest to help them in all terms. I have already mentioned some concrete issues, but of course, as I said, development in the Ukraine and in the other countries is not a way forward, but there are some returns which make the situation more complicated. So in my view, on what to do or how to deal with these countries, talk to them a lot and trade them a lot. Implement the free trade agreement. If it's necessary, let's correct it. Now I'm dealing with trade matters in the European Parliament. I'm even rapporteur for a poultry meat issue. I will not go into details, but it's quite an anecdote. It's quite amusing. And for me, it very well describes the mentality of the Ukrainian people. So according to this free trade agreement, they can export poultry meat, the best part, the chicken breast, in a quota. So there is a tariff rate quota determined for the exports towards the European Union. But being very innovative people, and we in Hungary know what meant innovation during the communist times. Everyone had to be very innovative to survive. So there is another tariff line saying that if it's other cuts, so it's not just the chicken breast, but some bone is in it, then it can enter to the European Union free of quotas and free of tariffs. So you can imagine what happened, and some very innovative Ukrainian businessmen, what they did. They started to export other cuts without any quotas, without any volume limitations to the European Union. In Slovakia and in the Netherlands, they established 2 farms where they, with a very easy cut, they just cut the bones, and it converted immediately into the best part, to the chicken breast, and by this they could avoid the quota. So it was a clear loophole. The European Commission, when it was negotiating this issue, was too genuine. And now, with an exchange of letter and ratification, etc., so now we managed to eliminate this loophole. But this issue, for me, demonstrates that, well, their mentality will not change, at least not in the near future. So we have to learn, the European Union has to learn how to talk to them, what to achieve, what will function with them, what will not function with them. So we should be more sensitive and more empathy toward them. And my recommendation would be a relationship on fairness and truth and frankness, without teaching them and without expecting them to be 100% as we want, because I don't think that it would work in the reality. Thank you so much for your attention. Good luck, good work for the participants of the panel. I can stay a little bit, but unfortunately my plane is leaving for Brussels, so you will forgive me if I have to leave you, I don't know in how many minutes. Thank you so much.